Mediation. Mediation is a formalized negotiation facilitated by a mutually agreed upon neutral third party, the mediator. The mediator you will be offered is certified or professionally trained and is a realtor. The mediation is a casual conversation within a formal structure and is protected by California Civil Code in that everything is confidential. Everything said in mediation stays in mediation. Nothing said or offered during the mediation between the parties or the mediator can be used outside the mediation. That includes open discussions, private caucuses, offers, and any agreed settlement. It's all confidential. So why should you participate? Because it works. Mediation in good faith produces results. By resolving disputes in mediation, the parties themselves retain control over the outcome. In an arbitration, the outcome is surrendered to the hearing panel. In other words, the hearing panel's decision is final. So what can the mediator do that you haven't already tried? The mediator can lower the emotional temperature in negotiations, affect more productive communication, uncover less obvious options, offer face-saving possibilities for movement, help facilitate solutions that might have been overlooked. So how does it work, and what should you expect? The mediation begins with all parties in a conference room, with the mediator conducting the meeting. The mediator reviews the mediation procedures and the rules of the day. The complainant goes first, uninterrupted, to present their case and review their evidence to substantiate their claim. The respondent then has an opportunity to present their rebuttal and present their evidence uninterrupted. The mediator will have already reviewed and received all the documents prior to the mediation, but may ask clarifying questions. No witnesses are present at a mediation. It is important that each party note whether or not they have witnesses prepared to testify at a hearing. The mediator will then facilitate an open discussion with all parties. In order to further the negotiation, the mediator will have the parties caucus, separating both sides to discuss privately the strengths and weaknesses of each party's position. During caucuses, offers between the parties will be negotiated, maintaining strict confidentiality. Mediated agreements are not just limited to a monetary settlement. This discussion continues between the two separate caucuses until there is an agreement or a stalemate. If an agreement cannot be reached at the time of the mediation, an arbitration hearing will be scheduled. The parties will still have the opportunity to reach an agreement up to the time an arbitration hearing panel convenes to render their decision. But if you do reach an agreement during the mediation, it will be drafted and signed right there. Additionally, the filing fee will be waived in whole. The confidential settlement will contain all the agreed details. Once signed, aside from fulfillment of the agreement, you're done. The complaint is withdrawn as if it were never filed. By resolving disputes in mediation, it gives the parties the ability to be heard, understood, find resolution without surrendering control, and the confidentiality that allows them to preserve their future real estate relationship. Thank you for listening.